He was kept illegally at Yamuna. Now, the Supreme Court records this in his judgment, that he was kept illegally at Yamuna Velodrome for 11 days and then released because they couldn't find any evidence against him. And then suddenly, 3 days after his release, he is shown to be arrested while boarding a bus at ISBT in Delhi with a full confession typed out in letter form, in expanded notation, in his pocket. After being kept for 11 days in illegal detention, he would actually keep a full confession in his pocket and walk around Delhi, a police officer. The trial court accepts this evidence and convicts him, sentences him to death. The High Court accepts this evidence and convicts him and sentences him to death. What happened to these judges? We'll come to that in a moment. What happens to judges in terror cases? The Supreme Court said this evidence is an insult to our intelligence. But yet, so Satwant Singh was one of the killers at the spot. He was, of course, he had to be convicted. There was no chance for him to get out. But there were three before the Supreme Court. There was Satwant, the actual person who fired the bullet. There was Kehar, and there was Balbir. Balbir was acquitted. Now let's come to the story of Kehar Singh. What was the evidence against Kehar? And Kehar Singh was convicted by the Supreme Court and sentenced to death and executed. What was the evidence against Kehar Singh? He was one of the, he was related again to Satwant. He was also a guard on duty. He was seen once standing with Satwant. Satwant was the actual killer. He was seen with him standing one day near a post, near a gate, on which an eagle alighted and sat. The eagle sat on that post. And both Satwant and Kehar fell on their knees, because the eagle is for Sikhs a symbol of the Guru. They fell on their knees and did some ardas, which I suppose is just a genuflection, a mark of respect. So that was one piece of evidence, that when the eagle alighted on the post, they fell on their knees and did a genuflection, and the Supreme Court said they interpreted it to be a sign from the gods that they must kill Indira Gandhi. It gets better than that. It gets better. Read the judgment. Read the Supreme Court judgment. The second piece of evidence against Kehar was that since he was related to Satwant, he and Satwant had been on a pilgrimage to the Golden Temple. And there at the Golden Temple, they had taken that prasad, which is called Amrit. And the Supreme Court said surely they had gone there. They must have discussed amongst themselves. And surely they would have planned and hatched this conspiracy to kill the Prime Minister. And surely the drinking of Amrit was a bond that sealed that conspiracy. Purely at the realm of speculation. This was the evidence on which Kehar Singh was hanged. Now, after the judgment, Justice Tarkunde wrote, you wouldn't hang a dog on such evidence. The Supreme Court judgment records what actually happened when Indira Gandhi was assassinated. It records that Satwant and the other prisoner, I forget his name now, Beyant, thank you. They opened fire on Indira Gandhi. She dropped dead. Satwant and Beyant threw down their weapons, put up their arms and said, we have done what we had to, now you do what you want. They had already disarmed themselves. The judgment records, if you could look at the extract from Sirvai. Yeah. This is the... I'll read out the extract from the Supreme Court judgment. At the spot of the incident, the two assassins are alleged to have thrown down their arms and said, I have done what I have to do, now you do what you have to do. The personnel of the Indo-Tibetan border police pounced on them and took them off to the guard room. What happened inside the guard room is not on the record. The fact, however, remains that both the assassins had been shot by the ITBP personnel. Unarmed, disarmed, taken into the guard room and shot. They were soon removed to the hospital where Beyan Singh was pronounced dead. and Satwan Singh was found to be critically injured. Satwan Singh survived after 15 days treatment. He is accused number 1 in this case. Now what I'm going to do is I'm just going to read out Seerwai's comment on this passage. The above passage shows that Beyan Singh and Satwan Singh had dropped their weapons and were unarmed. Therefore, shooting Beyan Singh dead was clearly murder. And shooting at Satwant, who had recovered, was an attempt to murder. It is a most distressing feature of this distressing case that neither the High Court nor the Supreme Court should have thought fit to direct the police to register an information against the personnel of the ITBP for the offence of murder and attempt to murder. The Supreme Court judgments do not record that the members of the ITBP had been brought to justice. This is at the highest level. So really, why shouldn't magistrates say that, when we see police torture evidence right before our eyes, we are naturally not going to do anything about it? Look what happened here. I mean, these are cases against the nation. We have to do our patriotic duty, as the Supreme Court did over there. In Nalini's case, you can just turn to the extracts on Nalini. In Nalini's case, Rajiv Gandhi assassination case, 26 people were arraigned as accused before the trial court. It was a Tada case. The first appeal went directly to the Supreme Court. Of the 26, all 26 convicted, all 26 given the death sentence. In the very first appeal, 19 are acquitted. What do you say about a judicial system that can move from one extreme of the spectrum to the other and administers the death sentence? Now, of the 7, 19 were acquitted. Of the 7 the Supreme Court convicted, it gave the death sentence to 4. Entirely based on confessional evidence and by bending the law. Of course, subsequently, the judges have some remorse, some pang of conscience, and then expressions of mea culpa in the public. Most notably Justice Thomas, who says he shouldn't have done it. But at a conference at that time, shortly after you all may remember the law that changed with Nalini. So the law, the question before the Supreme Court was this: if you are charged under Tada, which allows a confession to be admissible, and you're also charged under IPC, which does not allow a confession to be admissible, and the prisoner is acquitted under Tada, can the confession be used for the IPC offense? The Tada confession, can it be used for an IPC offense, even though he's been acquitted under Tada? And most astoundingly, the Supreme Court said yes. Because there was just no other way these 4 people could have been convicted. And at a conference at which I was present, when Justice Thomas was asked, how did you make such an absurd law? He said the government would have collapsed because we would have had to acquit everybody. The judiciary would have fallen into disrepute. It's only admissible under Tada, is used to support a conviction under IPC, even though Tada is held to be inapplicable and he was acquitted under Tada. And that is the law of the land today. Terrorist cases, because the evidence is so shoddy, are not difficult cases in law. They are very easy cases in law. They are hard in law for other reasons. In the 7/11 case, coming back to Wahid's case, so you have the ATS proceeding on the basis that these 13 boys from Simi have done this offense, and at the same time, the crime branch, under an equally high designated officer, Rakesh Maria no less, who later became Commissioner of Police, Bombay, you have the crime branch similarly investigating this case and filing a charge sheet in the same court against a different terrorist organization and saying they have done this blast. So, you have the ATS prosecuting these 13 boys from Simi on the basis of confession saying they have done the blast, and in the same case, very same case, the crime branch has filed a report before the same judge saying that this blast has been done by members of the Indian Mujahideen, naming them and mutually exclusive lists. In such a situation, the prosecution of these 13 proceeds. Now, their conviction is based entirely on confessional evidence. But the crime branch has also recorded confessions of the members of the Indian Mujahideen under the same provisions of MOCA, this very same section 18 or 30, section 18. So you have two sets of section 18 confessions. During the trial, the prosecution proves its confessions, which it has recorded under 18 of these boys. And then at the end of the prosecution evidence, the defense says, now look, we want to prove the confessions, which has also been recorded by the police, of those other fellows. And the court says you can't do it. That's not relevant to this case. It's not relevant to this case that somebody else has confessed to doing this crime. And they are barred from proving those confessions. That somebody has confessed to an authorized police officer under a statutory provision of law to having committed a very offense that is under trial before a judge is now held to be inadmissible and irrelevant. I could multiply these examples ad nauseum. It's very easy to fabricate evidence in a terror case. These are cases which are built on circumstantial evidence and confessions. Let me just tell you a little bit what happened in the Malegaon 2006 case. A blast goes off on Shab Barat, which is a holy day for the Muslims, and they go to the graveyard and pay respects to the ancestors who are buried there. The bomb is placed on the wall of the graveyard and the wall of the madrasa and the mosque adjoining the graveyard. The victims are mostly Muslim. Malegaon is a Muslim majority town. Immediately after the blast, the Mumbai police makes an announcement that this blast is the work of Islamic terrorists. And the very puzzled media in the press conference asked the police officer, how can you say that? They look at the victims, all Muslim. He says, well, it's only Islamic terrorists who have access to RDX. And this is at the second or third day after the blast. So this blast is investigated by ACP Shengal. He arrests 11 of these boys, 9 of these boys. He files a charge sheet against them saying that they have confessed under MCOCA before him, before another DCP, and then before the magistrate. And one of them has even agreed to become an approver. So this charge sheet is filed in the court. The case is then transferred to the CBI. He also claims to have recovered RDX from their homes and produces the RDX in court. So you have RDX recovery, and you have confessions, and you have an approver. That means one of them is willing to give testimony against his co-accused. And he's got the statement of the co-accused, of that approver, sworn before a magistrate in support of the charge sheet. The case is transferred to the CBI. The CBI rubber stamps the investigation and says, yes, this investigation is absolutely correct. And then it so happens that during the investigation of the Samjhauta Express blast, the NIA uncovers evidence that this Malegaon blast has been done by this Abhinav Bharat, this Colonel Purohit and Pragya Thakur, that group. And then the case is transferred to the NIA. The NIA takes over this investigation, investigates this case, and finds that the evidence produced by the ATS is utterly false and fabricated. And they say so in their charge sheet which they file. Now, you would have thought that such fabricated evidence on a capital charge, which would have definitely taken them to the gallows, would have aroused some action on the part of the state government. Officer Shengal, ACP Shengal, who fabricated all this evidence, who claimed to have recovered the RDX and even produced it in court, something would have been done to him. Nothing. So this is the impunity they enjoy. And why will they stop doing it? They will continue doing it so long as the state encourages it and fosters it. Some years ago, I had come to Bangalore for a wedding, and I woke up the next morning and the television channels were just full of this one particular news item, which was that certain Al-Badr terrorists were intercepted on the Bangalore-Mysore highway carrying sophisticated arms, for, of course, the Lashkar-e-Taiba, Al-Badr letterhead and Pakistan currency, the usual stuff. But there were sophisticated arms and satellite phones and the rest. The headline in the Times of India the next morning was, "Terror Stalks the South." All the newspapers ran their stories based exclusively on the police briefing, except the Hindu. The Hindu took the trouble to just probe a little deeper. So in the police briefing, they were given the names and the addresses of the places where these fellows stayed. And then the Hindu reporter actually went to their house and spoke with the landlady. I'll read from the report. Owners of the house where they stayed don't buy the Mysore police encounter story. The landlady of the Rajiv Nagar house on the outskirts of Mysore, where the two alleged militants stayed since August 16 this year, said, the person called Mohammed Koya rented a house and signed the rent agreement. Some plain-clothed policemen took him away around 15 days ago, along with the person we know as Ali. We did not hear of them since then. So why is this? You see, a blast which takes place in the trains is an actual event. It happened. The police can't close the file. They can't find the right people. They falsely implicate others. All right, that is one kind of terror case. But here, nothing has happened. It's like that Ansal Plaza encounter, where they dragged these people into Ansal Plaza and shot them, and the doctor saw it, and then that just completely destroyed their story. Their story there was that these terrorists had come to Ansal Plaza to plan to assassinate the Deputy Prime Minister L.K. Advani. Nothing of the kind. Even in this case, here the story was that these two Al-Badr terrorists were planning to blow up Vidhan Saudha in Bangalore. And they had sent maps of the usual things to Pakistan. But this is complete fiction, as we now know. So why did they create this fiction? One reason could be perhaps to neutralize these two people whom they wanted to get out of their way. But it's more importantly to create the fear psychosis. And this is something that you should really be cognizant of in terror legislations, in terror cases. You create a fear psychosis, you create a hysteria of fear, and it does two or three things. It makes citizens more agreeable to giving up their rights, to allowing the state to encroach on our rights, to surrender the privacy of our emails, the privacy of our posts, allow the interceptions to take place without authorization. The kind of encroachments on our rights that have been made by anti-terror laws has passed without even a protest. Just to refresh your memory a little bit, today, confessional evidence is de rigueur in terror cases, right? When it first happened in Tada, it was challenged before the Constitution bench in the Supreme Court in the case of Kartar Singh, and it was upheld by a wafer-thin majority of 3:2. The admissibility of police confessions was strongly opposed by the judges. 3 out of 2, that was the level of dissent. 2 out of 5 dissented and said this evidence should not be allowed. It became the law by a wafer-thin majority. But today, everybody relies on it. It's precisely to allow these kind of things to happen, to make it look normal that our phone should be intercepted, that unauthorized tapping should happen, that we will surrender our liberties of the kind of thing they're asking us for Aadhaar to do, without protest. You create this hysteria of fear, show these cases are happening when in fact nothing of the kind is happening. And it also serves the purpose of, as I said, now we come to the judiciary. If the man arraigned before a magistrate is deemed to be a person who tried to assassinate the Deputy Prime Minister of this country, or blow up the Vidhan Sauda. You think there is a magistrate or a judge in the land who's going to give him bail? When he is produced in a tortured condition before the medical officer in a hospital, you think that medical officer is going to write the injuries that are mentioned or that he can see on his body? It's to bring compliance not only at the public level but also at the administrative level, at the level of the judiciary. And the kind of pressure the judiciary is under when they're dealing with such cases, you